A special thank you to each of our subscribers who make this channel possible. Here's today's story. In a significant ruling, a federal appeals court has blocked President Donald Trump's attempt to use an 18th-century law to expedite the deportation of individuals linked to a Venezuelan gang. The decision, rendered by a three-judge panel from the Fifth U.S. Circuit Court of Appeals, cast doubt on the Trump administration's interpretation of the Alien Enemies Act of 1798, which was intended for wartime use. This ruling is poised to escalate to the U.S. Supreme Court, marking a pivotal moment in the ongoing debate over immigration policy and executive power. The case centers around the administration's designation of the Tren de Aragua gang as a threat to national security, which Trump had argued justified the use of the Alien Enemies Act. However, the court found no evidence of an invasion or predatory incursion that would warrant such extreme measures. The majority opinion, authored by Judge Leslie Southwick, emphasized that the historical context of the act does not align with the current situation. Lee Gellernt, an attorney with the ACLU who represented the plaintiffs, hailed the decision as a critical check on the administration's power. He remarked, "The Trump administration's use of a wartime statute during peacetime to regulate immigration was rightly shut down by the court. This ruling not only halts the deportations, but also reinforces the principle of judicial oversight in matters of national security." The Alien Enemies Act has a storied history, having been invoked only a handful of times in U.S. history, all during periods of declared war. The court's majority opinion pointed out that the Trump administration's claims did not meet the historical standards set by Congress for invoking such powers. They stated, "A country's encouraging its residents and citizens to enter this country illegally is not the modern-day equivalent of sending an armed, organized force to occupy, to disrupt, or to otherwise harm the United States." In a dissenting opinion, Judge Andrew Oldham argued that the court was overstepping its boundaries by challenging the executive branch's authority in foreign affairs. He contended that the majority's decision was unprecedented and contrary to long-standing legal precedents that afford the president significant discretion in matters of national security. The ruling also brought to light the administration's controversial practices regarding the treatment of detainees under the Alien Enemies Act. While the court upheld the procedures used to inform detainees of their legal rights, it underscored the need for transparency and due process in the deportation process. This legal battle comes on the heels of an earlier ruling by the U.S. Supreme Court, which temporarily blocked the administration's deportation efforts, citing inadequate notice given to the Venezuelan individuals facing removal. The High Court's ensigned order highlighted the importance of due process rights, stating that providing notice roughly 24 hours before removal without adequate information about how to contest that removal was insufficient. As the situation develops, the Trump administration has the option to appeal the ruling to the full Fifth Circuit or directly to the U.S. Supreme Court, where the final decision on the matter will ultimately rest. This case not only highlights the contentious nature of immigration policy in the United States, but also raises broader questions about the balance of power between the executive and judicial branches of government. With immigration policy being a hot-button issue, this ruling may have significant implications for future administrations and their ability to enact similar measures. As the legal landscape continues to evolve, it is clear that the courts will play a crucial role in shaping the future of immigration in America. That's all for this story. We upload videos every day covering many different subjects, so hit that subscribe button to stay informed. Thanks for watching.